Good afternoon, ladies and gentlemen. Welcome to join us for the inaugural HKIAC Annual Lecture in Beijing. I am Lin Yang, the Deputy Secretary General of HKIAC and the Chief Representative of the HKIAC Shanghai office. I want to say my special thanks to our distinguished guest, Professor Gabriela Kaufman-Koller, today, and many thanks to our chair, Mr. Matthew Gearing, QC, and our Secretary General, my strongest supporter to me here, Sarah Grima. Also, I would give my thanks to all the attendees today from CTAC, BAC, SPC, Beijing Courts, China University of Political Science and Law, Huizhong Law Firm, Zhongren Law Firm, and the leading practitioners in Shanghai, Beijing, Nanjing. Thank you so much to come to support HKIAC event in Beijing. Now, please allow me to speak some words about our today's agenda. Very simple. Matthew Gearing will give the opening remarks. Then Professor Kaufman-Koller will deliver the lecture on the topic of the research of efficiency when West meet East. Then our Secretary General, Sarah Grima, will moderating the Q&A session and deliver the closing remarks. Last but not the least, please stay with us and join HKIAC Arbitration Night, the reception. No more further words. Please join me. Welcome our chair, Mr. Matthew Gearing, QC.
Thank you, Lin Yang, and thank you everyone for coming today. The fact that there are very few spare seats, and indeed there is a waiting list, I think says something about the HKIAC, but also says more about our distinguished speaker, Professor Gabriela Kaufman-Koller, who I will introduce in a moment. Thank you to everyone for braving the notorious Beijing Friday afternoon traffic, because I know that it can be very bad, and particularly around this area it can be extremely bad. So thank you those who have braved the traffic or took the subway to come here. It is much appreciated. I will just say two things before I ask Gabrielle to come up and speak to you. The first is to say a few things about the HKIAC. Some of you know me. I think many more of you actually probably knew my predecessor, Teresa Cheng, who has gone on to bigger and better things in terms of being the Secretary for Justice in Hong Kong. During her tenure as chair of the HKIAC, she pushed rightly very strongly cooperation between the HKIAC and many colleagues, practitioners, arbitrators, and interest groups on the mainland. She recognized, many of us on the council, certainly me, recognize that it's extremely important for us to develop and nourish those links and to deepen them as years go by. We're proud of those links, but we do want to make them stronger and we want to make them more plentiful. Let me give you just 3 examples of the increasing importance of mainland and mainland parties to the HKIAC. Last year, on the HKIAC case docket, and there were some 265 arbitrations, of which more than half were under our 2018 rules, mainland Chinese parties were second only in their frequency to Hong Kong parties. Something over 40% of our docket, of the parties on our docket, is represented by mainland parties. So it's really such an important jurisdiction for the HKIAC that we have to, and we do willingly, look very carefully to the needs of Chinese parties. Secondly, and this really follows very much from the first point, now almost 20% of our cases are conducted in Chinese, either Chinese alone or dual language Chinese and English. 20% last year, percentage is going to go up year on year, quite obviously so. And thirdly, on a more basic, prosaic, I would say, working level, of our 8 legal staff, those dealing with cases, in the Secretariat. Now 5 of those 8 are bilingual English and Chinese. Also, very important to us, and you will expect to see, and I will certainly expect to see, those sorts of numbers increase. Obviously, what we need to do at the HKIAC, as other leading international arbitration institutions also try and do, is of course continue to develop the market and to look ahead and to represent best practice. We think we have done that again last year in the launch of our 2018 administered arbitration rules, which came into force on the 1st of November 2018. They were the 3rd edition, if you like, of our HKIAC administered arbitration rules, and now most of our cases, most of the HKIAC arbitrations now take place under the 2018 rules, or their earlier version of them, the 2013 rules. So they're really increasingly at the core or the heart of what we do at the HKIAC. The second thing, and far more importantly, was to introduce Professor Gabrielle Kaufmann-Kauer, our speaker this evening. Of course, we're all delighted that she accepted our invitation to come and speak at what is our first inaugural HKIAC lecture here in Beijing. Gabrielle, of course, is Swiss-based, but she's truly a citizen of the world, both in terms of where she's traveled, where she's studied, and where she practiced. I don't know, but I'm prepared to hazard a guess that barely a jurisdiction hasn't come before her in some shape or form in the course of a very long and distinguished arbitral career. Of course, she is currently the president of ICA. She is a member of our advisory board at the HKIAC, and we are extremely pleased to have her in that capacity. And of course, she is a preeminent international arbitrator. But you can read all of that in GAR, on her CV, and on various other blogs and so on. What's perhaps more interesting today is that Gabrielle holds a very long-standing and genuine interest in dispute resolution in China and on the mainland. She teaches students, part of her extensive teaching commitments at Tsinghua here in Beijing. She has recently been appointed to the International Commercial Expert Committee of course, the Chinese International Commercial Court. And going back many years, Gabrielle has been coming here, has been studying Chinese dispute resolution, and as many of you may know, in 2007, she produced a groundbreaking and extensive report on transnational arbitration in China. She continues to develop her interest in matters related to the mainland and dispute resolution even today. So I will not keep you from Professor Kaufmann-Kauer any longer. Gabrielle, thank you very much for coming to speak to us this evening.
Good evening, everyone. I am told that you're not bothered by the fact that I'm just in the middle, in front of the screen, and you can see me, but you cannot see the screen. So if you really are, I will try and step aside and allow you to see the slides. It is a pleasure for me to be in Beijing, to see so many friendly faces and meet new ones. I'm very honored by the presence of some, especially here tonight, and I thank them for being here. I'm of course also very honored to have been asked to deliver this inaugural lecture of the Hong Kong International Arbitration Center, one of the most respected arbitration institutions in the world. I'm looking forward to, as president of ICA, we will hold a Congress in 2022 in Hong Kong. I look forward to it, I also look forward to it very much to have 2 ICA events this spring 2019 in the month of May in this city. So in search of efficiency, when hope you can see it. Efficiency in dispute settlement is a constant concern, and the pursuit of efficiency is high on the agendas of all arbitral institutions, which seek to increase it by various means: emergency relief, expedited proceedings, early determination, to take just a few that I have gathered from the Hong Kong International Arbitration Center rules. One tool of promoting efficiency, receiving insufficient attention so far on the global scene, is the settlement facilitation by arbitrators. So settlement facilitation is my topic tonight. I must say that in the minutes that I spent chatting with one or the other in front of this conference room, I heard at least 3 times investment arbitration is a hot topic in China now. And I said, oh no, I have hesitated between speaking about this and investment arbitration. I thought everybody speaks about investment arbitration nowadays, so let's try to do something else. So I hope you're not too disappointed. It is about settlement facilitation. I will do this in 5 steps. I will first discuss give some clarification about the topic. Then I will speak about the legal cultures involved. Then speak about the pros and cons. And thereafter look at the transnational evolution before getting to conclusions. A few words about the topic. I'm speaking here about arbitrators promoting settlement within a pending arbitration. I'm not speaking about separate sequential proceedings, arbitration and mediation. So I'm not speaking about different individuals and different proceedings. I speak about the same neutral and the same proceeding. I will, of course, focus on commercial arbitration, but that doesn't mean that we cannot sometimes draw some parallels with investment arbitration. The topic goes to the heart of arbitration. What is arbitration? What is the arbitrator's mission? Is the arbitrator's mission to resolve disputes by a binding decision, or is it to resolve disputes, also including through other means as a dispute? In other words, it's a question of identity of the arbitrator and of his or her function, decision maker exclusively or dispute resolver. This is a topic on which there is no transnational consensus so far. There's been a powerful wave of harmonization of arbitration law and practice over these last decades, and most of the practices that we are used to are shared across jurisdiction. This one is not, and that's why I thought it was interesting to try and understand why it is not. There is, though, and you will see as we carry on, that there is an emerging trend of a transnational consensus with conceptions moving closer. But things are more complicated than that. And that leads me to my second step, which speaks about legal cultures. And here is the slide. I've stopped doing slides with lots of words on it, because then people read the slides and don't listen to what I'm saying. So now I'm trying to look for pictures. It takes a lot of time to find the right pictures, actually, but it's very fun to do. Generally, people would say that Western culture is opposed to settlement facilitation by arbitrator and that the Eastern culture is in favor. Now, that is an oversimplification, certainly. But as usual, when there is a difficulty to reach a consensus, one should look beyond the rules. If there is reticence to reach a common perspective, then it is probably because of something that underlies the rules, and it's often legal culture or just culture more generally. Years ago, I did an empirical research into ICC consent awards. And I reviewed about 60 consent awards and rendered over a period, but at least in certain cases, they had been, the tribunal had promoted the settlement. I then looked at the nationality of the arbitrators and also at their legal background. And on all these arbitral tribunals, there was at least, on all of the 13 that had engaged in settlement facilitation, there was at least one member, sometimes two, sometimes all of them, who was of either German, Latin American, that is Brazilian or Argentine nationality, and Swiss nationality. And then I looked at the legal systems of these jurisdictions from which these arbitrators came from, and in all these legal systems, the judges were empowered, sometimes even obligated, to attempt to settle the dispute before them. And obviously, if the judges were, the arbitrators were used to doing it as well. So these arbitrators were at ease with engaging in settlement facilitation because that was in line with their legal culture and their procedural traditions. Now, these are all from the West. And so the generalization of the opposition is an oversimplification. But obviously, there are many arbitrators from other jurisdictions than those that I just noted now would not be comfortable engaging in settlement facilitation. And now I should go to the next slide. So you would have on the left, you would have China, and it would not tell you this, is at ease with settlement facilitation. Then in the middle, you have those that I have found out in my ICC consent award study. And on the left, there is another one that the president will recognize, and others as well. It's the UK flag. The English system is rather opposed traditionally to arbitrators engaging in settlement discussions with the parties. And that is just stands there for many others. So, there are a number of divergencies here. Now, a few years ago as well, I did another empirical study, and Matthew Gearing mentioned it. I was the assistant of a Chinese doctoral student of mine. I interviewed Chinese arbitrators. I interviewed arbitral institutions, academics, judges, to better understand the settlement practice. It would be presumptuous for me to teach this audience that Chinese philosophy has long been divided between two, has long relied on two competing schools, legalism that favors top-down adjudication and Confucianism, according to which social harmony is best achieved by avoiding conflicts. And the latter prevailed with the result that the primary means of disputes became conciliation, mediation, and conciliation became the primary means of dispute. So it is no surprise that arbitrators here routinely engage in promoting settlements. Then I ask myself what the techniques are among those who are favorable to settlement facilitations. How do they go about it? And there, it's difficult to get to generalization because this is a matter of practice, and practices vary with people, but there are nevertheless some tendencies that there are two areas in the approaches which seem to be controversial and not practiced in the same manner. One is evaluation, that is the fact of giving views about the merits of the case, the strengths, the weaknesses of each party's position. And the second one is a private meeting of the arbitrator with one party without the presence of the other, or caucusing, if you prefer. Now we've identified the legal cultures and the differences. It is probably time to ask ourselves whether settlement facilitation is good or bad. I put this under the heading of in search of efficiency, so you guess what my answer is. But still, we cannot just take it for granted. We need to review this in more rigorous ways. What are the advantages? What are the disadvantages? And this leads me to my third part here. The first advantage, now maybe I should step aside again, so you can see, at least look at the pictures. The first advantage is, of course, efficiency. It's easier to pull a round load than a square one. That includes all well-known benefits of mediated outcomes or settled outcomes, agreed outcomes, as opposed to adjudicated ones, and that I will not, you know them, I need not, that is not my purpose here to repeat them. The question here is more specific. It is whether it is a good thing that an arbitrator engages, who is in charge of adjudicating the case, engages in assisting the parties in settling. Now I would submit at least 3 reasons to say yes. There's some reasons to be more reluctant, and we get to those as well. The first reason is that the arbitrator knows the file, and when as opposed to a third-party mediator who first needs to acquire the knowledge, was the result that there's a duplication of work and inevitable additional costs and delays. The second reason is the arbitrator is the master of the procedure, hence the steering wheel. He's probably in the best position to decide whether this is an appropriate case to suggest settlement, when it should be done. It may be done early on, it can be mentioned early on, but most often it is better to wait until the parties and the arbitrators have a better understanding of what the record is, and better measure what the risks and what the possible gains are. The arbitration obviously should not be done too late also, because then if it's too late, then the parties may not be interested in settling anymore because they have already spent too much money on the dispute, although they may also face post-award remedies and enforcement difficulties, which may in turn be an incentive to settle even late in the arbitration proceeding. The arbitrator is not only at the wheel for procedure, he's also at the wheel in respect of the outcome. In other words, he has the authority to make the decision on the claims. And the existence of that authority allows him to exercise some leadership that the mediator does not have, because the mediator has no decisional powers. Now, there is, of course, a risk of abuse, and I will revert to that, but that authority may well play a good incentive for the parties to be realistic and reasonable about their expectations and their demands. Another advantage that is often mentioned is the fact that the agreement can then be transformed in a consent award. That is certainly the case. It can then be enforced under the New York Convention. However, that advantage may lose some weight with the forthcoming signing and hopefully ratification thereafter of the UN Convention on the Enforcement of Settlements that will be signed in Singapore this coming August. It may also lose some weight because some institutions have mechanisms that even in separate mediation you can then switch to an arbitration and issue a consent award. So these are the reasons why this is an efficient mechanism that should be used. Now, are there also disadvantages that plead against it? Especially when meeting separately with the parties, the arbitrator can hear information that the other side does not know and the other side cannot rebut. And if that information somehow then nevertheless is in the mind of the arbitrator, it may impact the decision making if the settlement fails and be considered as a breach of due process. There are three options to mitigate or avoid that risk. One is that the arbitrator is barred from using the information, or the facts that he has learned in private meeting, she has learned in private meeting if the arbitration continues. That the situation, if I understand it correctly, here in mainland China. However, that does not entirely eliminate the fact that the arbitrator may be influenced in his mind by what he has heard. The second option is that the arbitrator discloses the facts learned in the private meetings to the other side if the arbitration proceeds, and that the solution of the Hong Kong arbitration ordinance. That may deter parties from being entirely open and frank in the private meetings, with the result that it may well take away the advantage of having private meetings in the first place and therefore defeat the purpose of the private meetings of the caucuses. The third option is simply to refrain from having private meetings with the parties and have any discussion that the arbitral tribunal may have with the parties on settlement with the two parties or all the parties present. Now, some object that this does away with the main tool of mediators, but then this is not exactly mediation. That's the first answer. And that the second answer is simply that this is the safest option. It will also avoid that the confidence in the arbitrator is impaired for one party. The IBA rules of ethics, for instance, propose this solution. If the arbitrators make a settlement proposal or give views to the parties, they should do it in the presence of both parties. So there is a second drawback, and that is the scale, and that is the risk to impartiality of the arbitrator being impaired. There's a fear that if the settlement fails, the arbitrator will remain influenced by what he has heard during the settlement process. In theory, this could lead to a challenge of the arbitrator and his removal. It could lead to an annulment of the award, and could lead to a refusal of enforcement of the award. In reality, this is more a perceived risk than an actual one, because if you look at cases around the world, I find one where a US court denied the enforcement of an award rendered and set aside in Italy because the arbitrators have overstepped the boundaries of their mission by getting involved in settlement discussions. But by contrast, there are many cases which state that arbitrators, that judges' involvement in settlement talks is perfectly admissible, and if it's admissible for judges, a fortiori for arbitrators with the consent of the parties, since this is in line with party autonomy, which is a cardinal principle of international arbitration law. There's a 2011 Hong Kong Court of Appeal case that enforced an award issued, if I'm not mistaken, in mainland China after a failed conciliation. Another risk is this one. I didn't find an image of an arbitrator pointing a gun at the head of a party. So that's the best I found. This is the risk of coercion or compulsion. And I was interested in reading that in the civil procedure law of China, there is a specific provision, if I'm not mistaken, it's Article 96, that says that if there is a settlement, it should be without compulsion, and the parties should feel free to settle or not. So that is the idea. Because the arbitrator, as I mentioned before, has the authority to rule on the case, there is, of course, this risk that he abuses this authority and puts pressure on the parties, or even if he doesn't put pressure, the parties may feel pressured into a settlement. That very much depends on the way this is handled by the arbitrator. It can be done, for instance, by saying, I can offer you my preliminary views on the basis of the record as it stands today. I may still change my mind once I have heard the evidence, but this is what I think today. And so that may help dispelling the risk of compulsion. As I said before, the authority of the arbitrator to rule can also be a healthy and sensitive towards reasonableness. Now, the conclusion of all this pros and cons would be, in my submission, that increased efficiency is indeed a significant added value to the dispute resolution process that can be augmented by settlement facilitation, and that the disadvantages that do exist can be mitigated or hopefully eliminated by the way the process is handled, and I'll come back to this in a moment. But before we go there, let's look at my fourth part, which deals with the trends and the evolution. I would like to speak about the evolution first by looking at some trends that we notice in recent years, and then try and see whether from there, on this basis, we can get to some guidelines or broad rules that arbitrators could follow. Settlement facilitation was not long ago not a topic of discussion at all in many places in the world. It was not within the toolbox of the international arbitrator, and on the transnational plane, it was in certain jurisdictions, as we've seen before, but it has made its entry in many texts recently, most soft law texts, institutional rules, but nevertheless, these texts are representative of a shift in thinking. The best shift can be illustrated by the ancestral notes. The ancestral notes are as a commentary on how to apply the ancestral rules, and it's the initial notes date from 1996, and they were revised in 2012, but without revising the relevant note. And the note said, well, on this issue, attitudes differ. Given the divergences in practice, the tribunal should only suggest settlement negotiation with caution. However, it may be opportune for the tribunal to schedule proceedings in a way that might facilitate continuation or initiation of settlement negotiation. So very timid, very careful mention of settlement facilitation. Then the notes were revised in 2016, and there it says, in appropriate circumstances, the tribunal may raise the possibility of a settlement between the parties. In some jurisdictions, the arbitration law permits facilitation of a settlement by the arbitral tribunal with the agreement of the parties. In others, it is not permissible for the tribunal to do more than raise the prospect of a settlement that would not involve the arbitrators. Where the applicable law permits the tribunal to facilitate a settlement, it may, if so requested by the parties, guide or assist the parties in their negotiations. Certain sets of arbitration rules provide for facilitation by the arbitral tribunal. So you see a significant shift in viewpoint in 4 years, actually, between 2012 and 2016. Among the other, well, I could give you more examples than those that are on the screen, and I will not go through each one because that will be a little long and boring. But the CDR, is a Center for Dispute Resolution based in London, have in, I think it was 2011, codified in quotation marks, of course, the proceedings that could be followed for settlement facilitation by arbitrators in a very detailed fashion. Is probably the most detailed, extensive fashion. The reason why I insist on this is that it emanates from an organization that is based in a jurisdiction that is traditionally very averse to settlement by arbitrators, and also that the task force was presided over by an English judge in addition to me, but the English judge here is more important. Now you will tell me it was Lord Woolf, and Lord Woolf it was already at the time of the civil procedure reform in England a very strong proponent of alternative dispute settlement. Nevertheless, it is an interesting development. Another illustration that is more transnational is the ICC. The ICC has included this in 2012 in their techniques for bringing more efficiency to arbitration and accelerating the processes. Then there is, of course, other rules like the Prague rules, which you may not be familiar. That's soft law. The DIS are the German rules. They are very strong on encouraging arbitrators to settle, but they are mainly emanating from practitioners who are used to it. You will also see, for instance, that the CTAC investment arbitration rules have a specific provision allowing investment arbitrators to facilitate settlement. That is less usual in the sense that so far investment arbitrators are more reluctant than commercial arbitrators, in my experience, to engage in settlement facilitation. So it is a very interesting provision. At the same time, certain recent surveys, and I say this with a little hesitation because they were mainly done by academics in the US, and therefore I'm not entirely certain about the sample of people they surveyed. But they have shown that at least in their part of the world, while the mechanism starts being known, it is actually not much used. And because arbitrators focus on their adjudicative role and do not see themselves as settlement promoters. Now, there was an article, a few recent article by a lawyer and a psychoanalyst focusing on the difficulty of changing tracks, and that how to go from adjudication to settlement, and how to make the tracks merge, right? You see the tracks merge here. Or do you simply, when everybody is on the adjudication track, it takes some initiative to at some point say, now, wait a minute, what are we doing here? Could we do this better? And that is a little disruptive because then everybody must change track or make the tracks merge. So that may be one of the reasons why in places where it is not that traditional, although it is known, it is not that used, is not used that much. Maybe arbitrators also think that they lack the skills necessary to settle the dispute. But that may be a miscomprehension of the mechanism. They do not need to engage as mediators would with different skills. They just need to, we will see in a moment what they can do or what not. It is, they certainly with their arbitrator skills can help bringing about a settlement. So that is an area, the merging of the tracks is an area where the experience and expertise of Chinese arbitrators would be very helpful, and some cross-fertilization would allow arbitrators from other regions of the world to be more courageous in engaging in settlement facilitation. Now I need to go back one slide. It is also true that there is another trend that is discernible in this region of the world that insists on separation of mediation and arbitration. And that you see signs of this in different places. The Hong Kong rules, for instance, say that if the parties wish to pursue a dispute settlement through other means, then the center will, then the arbitrators will suspend the arbitration. Or it's interesting to see that the HKIAC rules say that if the parties wish to conciliate, but do not wish the arbitrators to conciliate, then HKIAC will assist them through other means. Just the phrasing shows that the rule is that the arbitrators would usually be the ones to conciliate the parties. At the same time, as I mentioned before, HKIAC has incorporated the power of arbitral tribunals to settle investment disputes, so it is just an additional possibility, doesn't seem to be in lieu of arbitrator facilitation. Irrespective of settlement or facilitation by arbitrators, there's certainly a greater emphasis on the use of mediation, and that is particularly clear in the discussions, the debates, the initiatives about the reform of ISDS. Just a few examples: the CEPA, the Closer Economic Partnership Agreement between mainland and Hong Kong and Macau for investment disputes, has as sole dispute settlement method, if I understand it correctly, mediation. Or Indonesia, for instance, is one of the rare countries that has posted so far a paper on the UNCITRAL website in view of the forthcoming session early April in New York on the reform of ISDS, and there it advocates strongly mandatory pre-arbitral mediation coming after exhaustion of local remedies. So that is a different problem. But what my point here is to say that there is a strong point being made in favor of the settlement by way of mediation. I could give you other examples of treaties that provide for mediation, but that is not my purpose now. The evolution is, to me, this evolution is not contradictory. It is additional or complementary to the one that we are discussing here about settlement facilitation. What it certainly shows is a strong pursuit of efficiency by way of more settlement rather than adjudication. Now, having reached this juncture, I ask myself whether we could come up with some guidelines, in broad brushstrokes, of course, whereby the experience and the perception of the East and West could meet in terms of settlement facilitation. And I would suggest to you the following. So the arbitrator may facilitate. That's the first thing. Of course, if the lex arbitri, the law that governs the arbitration, has a provision, then there is no issue that the arbitrator has the power. If the institutional rules have a provision, then there is no issue either, because contractually the parties have submitted to it. The question is more difficult if there is no express provision in the governing act or in the institutional rules. And in any event, even if there is one, arbitrators should pay attention to their enforcement risk, because the enforcement jurisdiction may be opposed to settlement facilitation. So in any event, it would make sense to be quite cautious about how it is being done, but I would say even in the silence of the relevant text, it could be done if it is done properly. So what does that mean? No, sorry, I went a little too fast. Obviously, you would need to have the appropriate dispute. That is for the mediation theory has elaborated this. That's not my purpose here. You would also do it in appropriate circumstances that involves the timing, that involves the expectations of the parties, the cultures of the parties, and the like. More importantly, yes. Do I go the right way? Yes. You would need informed consent to the principle, preferably consent in writing, a waiver to challenge the arbitrators, as a waiver to challenge the award, and to seek and to object to enforcement only as a result of the settlement facilitation. And then you would need some additional safeguards, and like the protection wall next to these beautiful trains that you have in this country and that the whole world envies you. You would have to have some safeguards. You would have to have some agreement on how to proceed, whether there would be caucuses, whether there would not, and the like. There is, and as a safeguard, but that's really a last fallback position, There is always the possibility of the arbitrator, if the settlement fails and the arbitration continues and he feels prejudiced because he has been involved in the settlement facilitation, then he could resign. That is one possibility in the IBA rules. There is another possibility that exists in some rules, that if both parties feel that this arbitrator should not continue as an arbitrator after the settlement failure, they could revoke the arbitrator, but that is by agreement. I think these two situations are very unlikely to happen, especially they will not happen. They would, of course, be unfortunate, because then the efficiency objective is completely defeated, and you have to appoint another arbitrator, and you lose time and money. But they would not happen, I would submit, if the arbitrators proceed with the safeguards, with the consent, and they also use a simple, short, preferably evaluative process without caucusing. So that can be done. So you see, it's not like a mediation. It's really a different type of exercise. The arbitrator could, either he could give his preliminary views and see, as I mentioned before, on the record as it stands now, subject to my changing my mind, and so on. Here is some indication of my thoughts. He could also do it a little less affirmatively by saying, I look at the risks and the weaknesses on your side. There you have this risk. You really need to assess this risk. But you also have risks. They're different, but you also need to think about them. And then this will probably trigger a settlement negotiation. It may not necessarily mean that in that session the parties will settle. Probably they will not. But they will go home. If they're reasonable, they will have understood the message, and they will start talking. So that leads me to my conclusion, and it's good because I see that time flies. We have now, with a number of scholarly contributions, and also a lot of soft law, mainly practitioner-driven soft law, we have come to some understanding of what arbitrators can do to help facilitating settlements. On the face of the text and the academic thinking, at some point, I think West could meet the East and get closer to the practice that is current in the East. Maybe we're not entirely there because we still have what I call the track obstacle, is how to empower arbitrators to overcome that obstacle. That is more a psychological, practical, organizational issue than a legal one, because legally the requirements of proper process can perfectly be complied with. And that hurdle of the tracks that one has to make to merge, that will still require some more work and cross-fertilization between legal cultures and regions. So that should make us, make East, West meet. So that's my conclusion. There's a few elements of reading that you will, you don't have to take them now. If you're interested in the topic, I suppose the PowerPoint will be posted and you can take them from there. And that's it. And I thank you very much for your attention.
Thank you, Professor Kaufmann-Kohler, for your lecture. And thank you from me to all of you for coming out this evening. We now have a few moments where if you have any questions for Professor Kaufman-Kohler, you are more than welcome to ask. We have one just there.
Arbitration by definition is more efficient than litigation. And I'm sure there are exceptions. So you are suggesting that efficiency can be further improved by mixing arbitration with mediation. Are there empirical studies to suggest more people are now flocking to arbitration because of the mixing?
There are no empirical studies on that, no. Unless they are in this country that I don't know, it could be because it has been traditionally done in this country, but I'm not sure, and somehow there is not much use of it in other places so far, except those that traditionally have done it. So it's a good question. Maybe that will be the reality test for efficiency. I could concede that, absolutely.
I appreciate your talk, particularly looking at the specifics of the process when West meets East on the combined process of mediation combined with arbitration. Now, my question is from the choices of the parties, because we have litigation, arbitration, mediation, negotiation. All these are, open to the party to choose. And the party choose arbitration, then go to arbitration, and then it's exclusive, so no litigation. And then in arbitration, my question is, do you have a choice? Choice of combined arbitration, choice of separate arbitration, separate with mediation, or any other further choices? So that's my question. Thank you.
Yes. There are multi-tier dispute resolution clauses in contracts, but many arbitration clauses are just plain arbitration, and so the parties will go to arbitration, or they agree on mediation, that's right, and they can still do that. To me, it is not that much a question of choice. It's just that when you are in the arbitration, the arbitrators should have the power to suggest to the parties because it makes sense at this time. And we all know situations where we really say, oh, why are they fighting? They're both losing here. And maybe they have tried already hard and they simply cannot for reasons that the arbitrator does not know. But maybe they just need a little push. And if the arbitrator can give the push, but then, of course, it's always subject to party autonomy in the sense that the parties must consent to the arbitrators doing it. If they don't consent, then it stops. And I think that is right because arbitration is a creature of party autonomy, and it should remain so, yes.
So my question is a bit harsh. So in your view, how do you reconcile between an arbitrator's motivation to facilitate settlement and an arbitrator's financial gains from sitting through the arbitration, sitting through this entire complicated and long-lasting arbitration, the financial gains between, and also with his motivation to facilitate settlement?
Should I give a harsh answer?
Yes, of course, go ahead.
How does counsel do this?
Yeah, I'm just asking your view on this.
No, but I'm asking how counsel will manage the settlement prospects. No, the financial gains, it very much depends. First of all, it's not the priority and the thinking, I hope, of arbitrators, right? But second, it depends on the system, but if you have a system that's on hours spent, then it makes no difference because the hours spent should be paid. If you have a system that takes into account more the value of the case, then it is up to the institution to be fair with the arbitrators and recognize that they have had a significant part in a satisfactory resolution of this dispute. And if they do so, I see no difficulty.
Actually, I have a question for you. Actually, I would like to share news with you because we are Chinese lawyers and arbitrators. We understand that according to the PRC arbitration legal system, and the arbitral award is final and binding upon both parties, and nobody can appeal to the court unless the court will have very limited power to review the case only due to some limited reasons such as lack of jurisdiction or defect of procedure or somehow like that. But I heard that 2 months ago that Shenzhen Court of International Arbitration has introduced their new arbitration rules. And in their new arbitration rules, there is a new system called optional appellate arbitration procedure, which means at certain, upon to the prior consent of both parties can apply with the arbitral institution to review the case or retry the case. So could you please somehow comment on this new rule? Do you think it's a progress or advanced progress?
I've seen these rules and I was interested in seeing them. I was not sure what the thinking behind them was. I think in most systems I know, if the parties want to build in an appeal, they can do so. There are examples. Commodities arbitrations, sometimes some systems have appellate bodies. So that is not out of the question. I have reviewed this in quite detail in the context of the appellate body that is being considered for investment arbitral tribunals. So it's a similar type of issue. If the parties agree to it, then that's fine. My question is, why would they agree to it? What are the grounds for appeal? Is it just an appeal on legal error, or is it also an appeal on the facts, which will, of course, make a big difference in terms of a duplication of effort? I'm just not entirely sure what the reason was for introducing this. Again, it is entirely subject to party autonomy. So if parties are not at ease with having one stop decision and need a second one, they could agree to it, but obviously it will be longer and it will be more expensive. So in other terms, it will be less efficient. Yeah.
Okay, well, thank you, Professor. Thank you for the excellent lecture. I would like for your confirmation or your opinion about a general statement here in China about the arbitration, combining of arbitration with mediation, this op-med-op procedure. And the general understanding in China, or at least many people have that understanding, is that this type of combination or practice is acceptable to legal communities from European civil law jurisdiction, but the common law jurisdiction have more concerns about this, the reasons you mentioned about breach of due process or contamination of arbitrator's mind, something like. But we understand the German lawyers, Swiss lawyers, and we see from Prague rules, there's even more aggressive provision in it. So is it true that this Chinese practice of combination of arbitration with mediation, and actually we have litigation with mediation in practice, is this more acceptable in your experience? Is this statement is true that the civil law tradition legal community have found no problem with this, but there's bigger problem with the common law jurisdiction? Thank you.
Yes, that's right, but I tried also to look at common law jurisdiction, and for instance, I thought that English law would be more resistant than US law, for instance, or in the US judges would feel, I mean, many don't do it, but they would feel like they could have a settlement discussion with the parties. So in general, you're absolutely right. I think that depending on how it is done, it should be acceptable to everyone worldwide. And you have noted certainly that I purposefully did not use Med Arbor or Med because I wanted to get away from the idea that you are mediating like a mediator would, with all kinds of interest-based techniques and sitting there for long hours at night and having all kinds of exchanges with the parties. That is not, I think that is difficult to reconcile with an arbitrator's job. However, if it is done in a more channel structure, contained way, then I don't see why an award like this would not be enforced in a common law jurisdiction.
My question is, do you think there should be some oversight exercised over the conduct of arbitration institutions and the arbitrators, or they should be held accountable under some circumstances? For example, if an arbitration case drags on and on forever, what can parties do? What remedies do they have?
I thought you wanted to oversee the institutions, but that's not your question, right? No, because it's a question I ask myself. You know that in the course of the reform of ISDS, there is the suggestion that we should do away with party appointment, and therefore appointments should be made all by the institutions. Now, that's fine, will give maybe some more legitimacy to the system, but then who are the institutions and who will check the institutions and so on. But that's not your question. So your question is, yeah, the institutions have the power under most rules to revoke an arbitrator who does not perform his duties. Now, whether they do it or not is a different question, but maybe they should do it more, absolutely. And just the threat of there being this oversight enforced may work miracles.
My question is, according to your study of the ICC's consent award, can you find any commonalities among those cases when you're suggesting we should put some guidelines like selecting appropriate disputes? So what is appropriate dispute? And is it really possible for institutions or researchers to put a guideline that says this type of disputes or this type of the merits are suitable for these mechanisms?
I don't think I can from the review of the consent award, because the consent awards often do not say much really about the dispute. So they say a little bit about the procedure, but they don't give the content. So it's difficult. In general, I think we all know which disputes can be settled and which cannot, or we have an intuition, and mediation specialists have their lists. For instance, if the respondent is in bad faith and willing simply to save time, then he would he would say yes to a mediation attempt, but there would be no reasonable prospect to settle at all, because that's not what he wants. He would just buy the time. So these are things that hopefully one would see and then not engage in it. Or then it also depends on whether there is a possible win-win solution or there is none. What type of dispute it is, depending on that, whether there's just an amount at issue and whether the parties are far apart or not that far apart. I mean, these type of issues.
I have one question about the best timing for the arbitrator to conduct the settlement. we understand in the international arbitration, normally it will have one hearing after both parties file their submissions, legal expert opinion, or witness statements, and then both parties sit down with the arbitrator to have a hearing. If the case is very complicated one, the hearing can last for 2 or 3 weeks. I think maybe at that time, after all the arguments are made by the parties, the tribunal get a full picture of what happened and the disputes. When do you think the best timing for the arbitrator to conduct the settlement? If the timing is at the end of the trial, then why do you think such settlement discussion will save the cost of the parties? Thank you.
I am not entirely sure what the right answer is to this, and maybe there's no one answer that is applicable to all cases. You could say that it is after the written submissions, when you have the expert reports, the witness statements, and the briefs, then the arbitrators knows enough about the case, and the parties know also enough about the case, and especially their opponent's case. Now, this is not always right. Sometimes it is during the hearing that you hear something and you realize, why did this witness say this? And maybe that is the entry door into the idea of a settlement. So it is difficult to say generally. Now, does that mean that it is too late in the course of the hearing or after the hearing to make a settlement proposal to the parties? I don't think, not necessarily, because you still don't have the award. There's always a litigation risk as long as you have not seen the award. And then you have the enforcement risk, the annulment risk. I mean, it can still last quite some time. So there may still be incentive to settle even at a late stage of the arbitration. What was that?
Helen, I was going to ask a very similar question. And I was thinking about that, Gabrielle, during your talk about the timing point, because we know that sometimes what happens, at least in big international arbitrations, is there will be a request and an answer. Procedural order number 1 will set the procedure. Frankly, at that stage, arbitrators don't know that much about the case. Then big cases get set on this sort of 12 to 18-month train ride of normally 2 big briefs, often 2 big briefs on both sides, maybe disclosure in the middle. Arbitrators sometimes engaging, but quite often not, or to a greater or lesser extent. So, as Helen was saying, they're not really necessarily fully engaged until the case, a lot of money has been spent on the case. Now, other arbitrators, as you know, lament that to an extent, and some ideas being pushed, for example, in this part of the world by Neil Kaplan, is the idea that the arbitrator will engage at an earlier stage, perhaps after the answer and the response, will ask for, say, a 20 or 30-page statement, as best the party can put it at that stage without prejudice to their ability to develop later, and then a one-day hearing to sort of bat out the issues and to try and settle the procedure. Now, it occurred to me that if one did that, at that stage, the arbitrator might be able to facilitate a bit more than waiting 18 months until $5 million have been spent.
Absolutely, that's a good point. There are also proposals for doing some kind of settlement window at some point, that would be one possible point, and that would be built into the calendar from the start, so everybody knows this is what is expected. It might be a good idea to do this, yes.
Yeah.
Oh, thank you for the opportunity for the last question. Because my question is, because I know today we're talking about sort of meet-up. It's not called meet-up, but you have a mixture of arbitration and mediation. But the other option is you just have mediation. or you won't necessarily have your arbitrators as your mediators, because we as counsel sometimes you would say, okay, this is an opportunity for you to mediate, but you not necessarily you would have your arbitrators to mediate, right? So that's the other option. I know we've discussed, you've discussed before that there are cost concerns. You have your arbitrator to mediate, then that saves time and money, but there are also other concerns. For example, to have a different set of people to be your mediators, maybe it may be worth it, because some people say mediation skills and arbitration skills are complete different skill set, and there are also concerns that Professor Liu just raised about contamination, etc. I'm just wondering, whether we have thought through whether that is an alternative option.
No, we have thought through very carefully. I can tell you. No.
to hear
Your point is taken, and there's no reason that if the parties want a real mediation, they should go to a mediation. They should not go to arbitration and settlement facilitation. That's their choice. That's their right. They should.
Yes.
They can't go to mediation. By the way, I see there's a number of scholars in this country advocate in this direction now, which to me is a way to get closer to the West, which is precisely moving to the East. So it's a little funny back and forth going on between the West and the East. But you're absolutely right to say that if the parties want to mediate, they should have a real mediator, and that mediator should not be the arbitrator. If they are happy with an arbitration, and at some point during the arbitration it makes sense to settle, then why would they not take advantage of the person who's there rather than stop the arbitration and start a whole new mediation? That's just my point.
Well, everybody, please join me in giving Professor Kaufmann-Kohler a round of applause, and thank her for her lecture and her answers. So it's now to me to make a few closing remarks, and I would just go back to what Professor Kaufmann-Kohler said at the beginning of her speech. She was worried that the topic would not be of paramount interest because there's so much interest in investment treaty arbitration, and I agree that that is an area which is incredibly interesting, but I think it's clear that there is a lot of interest in this topic as well. And I also think that Professor Kaufmann-Kohler is perhaps the perfect person to speak about it, given that you are a Swiss lawyer, but you have traversed all jurisdictions in the world, and you have had, you've done careful studies on how mediation and arbitration may be combined in this part of the world. So thank you very much. Let me just offer a few comments from the point of view of HKIAC, because as an institution, like the other institutions present, one of the things that is always on our mind is how to increase efficiency, because we know that that's what parties care about, time and cost and making proceedings efficient. But up against that, the strong pursuit of efficiency is always the balancing of due process and making sure that any award at the end of a process or during a process is enforceable. So this is certainly what exercises our minds a lot. And when we were revising the 2013 rules, we were thinking about this, and we were thinking about the fact that at HKIAC and in Hong Kong, we have so many mainland Chinese parties in our cases. And we know that in this jurisdiction, mediation and evaluative mediation is normal and it's effective. And so we needed to think about how we can encourage that. And the provision that you alluded to, Article 13.8 in our new rules, is an express manifestation of the fact that if the parties want to go and try another means of settlement during the arbitration, that is expressly provided for. If it doesn't work, then any party can request the resumption of the arbitral proceedings. Now that is perhaps just making express what we already know, but there is some value in doing that in rules so that the parties and the arbitrators turn their minds to it as an option and that courts are happy with it as well. As Professor Kaufmann-Kohler has pointed out clearly, in Hong Kong, there is not a tradition of an arbitrator acting as a mediator and then potentially again as an arbitrator if the mediation attempt fails. And I think in some ways that shows how diverse the jurisdictions between Hong Kong and mainland China are, notwithstanding how proximate we are, and how much interconnectedness there is, not just in dispute resolution, but also in trade and investment. And we are excited to watch what happens with the closer economic partnership agreement in which investment disputes between a mainland investor against the Hong Kong SAR government and vice versa, Hong Kong investors against the mainland government, will be resolved using mediation. And HKIAC is one of the institutions that will be helping to administer those mediations, and both governments have put together lists of highly qualified mediators for those kinds of cases. So that's something that we look forward to watching evolve. In terms of what we see parties choosing, we are a one-stop shop. So we offer arbitration services, mediation services, domain name services. And that's, HKIAC has been that way since the beginning. And we see, for example, the China International Commercial Court is also a one-stop shop with mediation available, arbitration available, litigation available, as well as consultation available. So that is attractive, and there is a lot of interest in mixing modes of dispute resolution. We did a survey within HKIAC to look at all of the clauses that we saw coming through our doors over the last 4 years to see whether parties were putting in place mixed modes of dispute resolution. And what we found amongst over 1,200 clauses was that parties were choosing mixed modes in approximately 17% of cases. And the most common other method, apart from arbitration, was negotiation, so a formal negotiation process, sometimes with the authorized persons identified, sometimes not, sometimes with a clear time limit established, sometimes not. And we saw much less a mediation to arbitration process agreed upon. That only came up in 2% of the clauses that we looked at. There is, of course, a big qualifier here in that the clauses that we see come to us are those that have come to arbitration, so they haven't been resolved by mediation. So it just gives us a partial view of the issue. So that brings me to the end of my comments. I want to thank you again, Professor Kaufmann-Kohler. It's a great honor to have you as our inaugural lecturer, a hard act to follow. We hope that we will be able to attract other speakers, but we do look forward to holding this again next year. So it's just now for me to thank once again very much the China University Political Sciences and Law, Zhonglong Law Firm and Haozhong Law Firm for their very generous support for this occasion. Thank you very much.